Hey friends, before you go on that green card, things are starting to get really interesting with U.S. immigration. Can Donald Trump give you a green card? Hey guys, before you file for your spouse, Hey there, friends. It's nice to be with you today. Come on in, join this live session. As you're coming on board, say hello. And who is watching today? Type in freedom now. Type in freedom now, freedom now. If you believe that freedom is, freedom should be now. Okay, come on in, say hello. Is my audio on? Testing. I think it is, but you guys tell me, say hello and let me know if my audio is good. Just tell me it's good. I could hear you. I can hear you. I can hear you. Let me know whether the audio is working. Hello there. Hello from Queens. Freedom now. Freedom now. Is my audio good, guys? It's great to see you. Give me some hearts and likes and let me know how things are coming along with the audio. Hey there, Joseph. Hello there, hello there, hello there. Freedom now, Stephanie, good to see you. Freedom now, come on in, guys. Is the audio loud and clear? Is the audio good? Come on, someone tell me. Okay, Joseph says yes, great, wonderful. Thank you for that, Joseph, and others who are letting me know. Guys, I hope you had a terrific weekend. We're going to have our immigration Q&A show today and go through your immigration questions. Immigration is tough. U.S. immigration is one of the most complex areas of our law. And you guys understandably have questions about your case. And for some of you, you're already working with an attorney and things might be going well, things might not be going so well for you, but in any event, you know that it is tough and you need your questions answered. So I'm happy to be with you today. However, I will not get to everyone's questions, okay? It's going to be impossible to do so. So what I'm asking is that if you'd like to go deeper with us at McBean Law, we'd be happy to meet with you and go deeper with you about your case and go through all of the questions that you have and get you your answers, okay? You could have a consultation with us, meet with us. Call us at 888-462-4006 or go to McBeanLaw.com where you can request an appointment with an attorney. It's so nice to have you all with me today. Let's get into your immigration questions. Thank you, Freedom Now. Type in Freedom Now, Freedom Now, Freedom Now. Also, let's see. Let's go to the first question. Thank you, guys. Thank you. Thank you. It's good to see some familiar faces here. Hey there, Sherry. Good to have you. Martha, thank you. Edgardo from Florida. Thank you for being with me today. All right, let's go ahead and type in your immigration questions. Now, the first question is, does USCIS have reasons to possibly deny the I-601? Yes, absolutely. They have a lot of reasons to deny an I-601 waiver. Firstly, they can deny the waiver because you didn't prove that your U.S. citizen or your green card holder spouse or parent will suffer extreme hardship if you're deported and have to leave America. That's a huge burden to meet. And if you fail to do that, absolutely, they will deny the case. If you file the waiver to address a problem that the waiver is not connected to, yes, they will deny the waiver and tell you that you don't have a way forward because no waiver is available for your particular problem. So yes, the government has many reasons to do so. And if friends, do not lose heart if your I-601 waiver is denied. We work with people who come to us who have a denied I-601 waiver. And we take a look at what the reason is for the denial and whether there's a way forward. And if there's a way forward, we prepare a refiling of the I-601 waiver. So don't lose heart. Okay, thank you for that question. Any update on PIP? I have not seen any updates since my Friday news video to you guys. If you've missed Friday news, go ahead and check it out. I've been very busy this morning and I have not had time to look into PIP. We're waiting on the update actually from the federal, from DHS, from the federal, in the federal register, okay? And while I'm doing this, I'll check to see if there's anything. Why this update from the Federal Register is so important, friends. It's important because, and I don't see it yet. It's important because it will tell us about who is disqualified, very specifically who is disqualified from PIP based on the fact that they have a criminal record. That's one of the major reasons why this is so important. Secondly, we want to know that this is still going forward, right? That the government is still committed to this. And right now they're behaving like this is something that they're not that committed to right now, based on the fact that today is August 12th and the applications for PIP, the period opens up on August 19th. And I'm also on USCIS's website to see whether they've sent out anything, and they have not published something around PIP yet either. So my take on it is that from a political standpoint, something political might be going on behind the scenes, in which someone is whispering into the ears of various policy advisors, political advisors, that now might not be a good time for this because this appears soft on immigration. On September 10th, you have a debate coming up on ABC with Donald Trump that he's made such a big deal about. You've got to be quiet with immigration or appear tough, right? And so that's what could very well be going on behind the scenes. So pause on these types of initiatives until January 1st, right? That's just my speculation because I speculate things politically all the time. So if that is in fact what's going on, then they're going to put a pause on this. But let's wait and see. Hopefully I'm wrong. I would really love to be wrong about this one, all right? So no update. Freedom Now, Yonkers is in the house, not too far from us. We're in White Plains, New York. So come on over, Karen, and meet with me in person or one of my colleagues. We'd love to meet with you. Thank you. Amar says, I filed the motion to reopen with BIA, with ICE. ICE had agreed to it. Great. It's been 7 months now, no answer. I wouldn't worry too much on that, Amar, because it's not uncommon for the BIA to take a long time just to sign off on this. It's at this point, it's administrative. Normally, they will not challenge the decision by ICE to join you with this motion to reopen your removal case. They normally just sign it. At least that's what they've done for all of our cases, our motion to reopen. So I'm expecting that they will do that with yours too, unless something funny goes on, right? I don't know. But in any event, they normally will just sign it. 7 months is not uncommon for the BIA, and there is nothing that you can do to push that one along, all right? Freedom Now, thank you. What would be the estimated price for parole in place for certain non-citizen spouses and stepchildren of U.S. citizens? So the USCIS has not in an official way published the fee for PIP. What they have done, based on what I've been told by some of my colleagues, I haven't looked into it myself, is they have published a non-military parole in place filing fee. And you could go find that, Mr. Dominguez, go find that on USCIS's website under fees to see what this non-military parole in place filing fee is. I'm waiting for the Federal Register to confirm that whatever they've already published on their website is in fact the filing fee. Immigration lawyers will tell you that what their fees are normally during a consultation. That's the way many of us do it. Thank you. Freedom Now. So now this is a serious question involving an issue related to second-degree domestic assaults. For an immigration application, will immigration authorities focus on the charge of second-degree domestic assault or on the resultant conviction, a terrorist threat, gross misdemeanor served? I have to take a sip of my coffee for this one. You know, immigration is going to focus on both of those in a very significant way. Very significant way. All right. The next question is, and guys, come on in, lighten it up. Say freedom now. Say how you're feeling. Say how, your weekend was. Let's lighten this up, okay? And lighten it up. All right. Can an overstay visa apply for EB2 national interest waiver with an ADHD U.S. citizen child? So the overstay visa part is going to be the biggest problem. When you're seeking the EB2 national interest waiver, the question is whether you could adjust your status or not. And you mentioned here that you've overstayed your visa, which means no, can't adjust status. You'll have to consular process. And in order to do that, you're going to need a waiver to forgive, so to speak, or set aside the issue of your unlawful presence in the United States. That waiver requires a U.S. citizen parent or spouse. If you don't have one of those, you will not be able to successfully complete the national interest waiver process, even with a child who has ADHD. Okay? Thank you for that question. Anthony says, do you have to be undocumented or come in through Mexico or by plane to qualify for Biden's parole? Which parole are you referring to? Are you referring to the parole in place for spouses of U.S. citizens and the stepchildren, or are you talking about a humanitarian parole, which we have a number of humanitarian parole policies in place, so to speak, that allows people to come into the United States on a humanitarian basis. Now, I'm assuming that you're talking about the big one that I've been talking about all summer, parole in place for spouses of U.S. citizens. So the biggest issue is you have to have not been inspected and admitted. You must have illegal entry on your record. Illegal entry on your record. If you entered by a plane and it was an illegal entry, there is an argument that could be made that you illegally entered the United States and therefore you're eligible for PIP. It doesn't have to only be the border people who are eligible for PIP. Thank you. What happens next if the judge terminated your removal and you have a VAWA case pending? So after your removal case is over and terminated, you would then be eligible to apply for adjustment of status with USCIS. So that is typically the next step, whether it's a VAWA case or a family-based petition that had already been approved. Freedom now, freedom now, freedom now. Amy says, I like how Amy has framed it from Queens. She says, thank you for giving me hope. To God be all the glory, in all caps. Okay, let's keep going. What happens if you came with a visitor's visa and you stayed for 15 years? Can we help you? So we might be able to help you if you have an option for a green card. Yesterday in our newsletter, we testified about our client who I think he has been here for 23 years, and we were able to help him. It depends on whether you have a pathway to a green card or not. You can be here for 10 years and then a pathway opens up for you, or 15 years and it opens up for you. Watch my playlist on overstay visa options on YouTube and learn about the different options. Thank you. I see that Arizona is in the house. Someone says that I did a congressional inquiry after I had an interview 1.5 years ago, and I still haven't heard anything back. Well, no, you say, and USCIS responded that they're doing a background check and that you should wait for your background check results. What should I do now? So, when did you when did you get the response from USCIS? Your case, there's something going on. Something, it sounds like it's going on there potentially with your case. For it to, first of all, I don't even know. Well, here's what I do know. Let's talk about what I know. So you interviewed, which means that you've reached a very significant point in this journey to get the green card. Either something happened at the interview that triggered additional background check, or maybe if they had issued you a request for evidence or a notice of intent to deny and you've responded, and based on your response, it triggered additional work for them to do to drill down and really check on things with your background to see whether everything is right with your filing. And if everything, and depending on what they're looking for, it could take a year or even longer for them to do their research to see what else is going on, or if they want to trigger the fraud unit to be involved in an investigation. That does take time. Takes time for these people to really, because they have a lot on their plate, right, around fraud. So it takes time for them to coordinate a site visit. They have to figure out who they're going to try to interview and certain things. So they're doing some background check on you, and I think that you could wait a little bit longer, or you can try to do the mandamus through an attorney to file that lawsuit for you in court. That would force them to take that next step. But be careful with the mandamus, because if you have a bad case, bad from the standpoint of it looks like they're going to deny it. It looks like they're going to deny it based on the facts. Why spend so much money with a lawyer to file the mandamus? That's my argument, and we're still doing well, by the way. We still have a lot of clients. We're still doing extremely well, but we do turn people away, and we help them to understand if your case is going to be denied, why spend this money now for a mandamus? We could take a look at the background, take a look at the records, and more fully advise you about the direction where USCIS is going with this. And for some people, they may have to do a refiling of the case to address some of the problems that came up with the first filing. So you could have a discussion with us. We'd be happy to talk with you if you're in this situation, waiting so long for your case to be approved after you've been interviewed by the government. Thank you for that question. So reach out to us for further discussion. Freedom Now. Let's see. We don't do the K3 and K4s in our office, Janet. We only focus on, we focus primarily on the family-based process. We don't do that particular petition because normally the processing time, the approval time from the last time I looked at it, which is a very long time ago, because we don't do that kind of case here. The processing time for the K3, K4 is very similar to the I-130. So we just do an I-130 process. We focus on the I-130 for our clients. But that's not a case that we would do here. Let's see. If a U.S. citizen has not filed taxes consistently, does that make them ineligible to file for their spouse? Also, how negatively does a child support case affect the filing for the spouse? So, Stacy, if your spouse has not been paying his taxes consistently, as you've said here, the way that it could impact your case certainly is on the affidavit of support side of things. That's where it could be an issue with needing to show the income, the current and past income of your sponsor. If he doesn't have the right records on the tax side, there's other records that can be shown as well. Or you could also get a joint sponsor with your case. It should not the fact that this person is also on child support does not actually negatively impact your filing, the spousal filing case. I think that you'll be fine in that regard, but there are some issues there, so you should definitely contact us so that we could go a little deeper with you about these things. Nuendu is asking, can an overstay visa who has an ITIN and files taxes, can that person apply and get a work authorization? Not unless they're connected to a case that makes them eligible for work authorization. You would think, right, that if the government is giving you an ITIN and telling you to use this to file your taxes and pay us, government, taxes, that along with that should be a work permit. That sounds so logical, right? But they don't do it that way. The work permit is connected to an immigration process, not as a standalone just because you're filing your taxes using the ITIN. Thank you for that question. Is there a way to file for the crewman visa married through a marriage case here for over 20 years? There's a bar in our system to adjust in your status. You would have to, your spouse can file the I-130, get that approved. Then you're going to need a waiver for your unlawful presence, and then you'll have to finish the process at a U.S. embassy if you entered the U.S. with that crewman visa. Why does the I-130 take longer than the I-45 petition when citizen child files for immediate relative, like the father? Why does the I-130 take longer than the 485? Normally, the 485 cannot be approved until the I-130 is first approved. My husband got approved for his I-601, but he got a marijuana charge 15 years ago under 3 grams. The records are all messed up. My question is, will this law protect him from going back to get approved? So he got an I-601 approval in connection with what? The adjustment of status process? Is he seeking he was seeking adjustment of status? Stephanie, you're going to have to reach out to us because I'm a little confused. I know that you got your I-130 approved, but now you're saying that he also got an I-601 approved, yet you're concerned about whether he would have to go back home. So that doesn't make much sense. Normally, the 601 is filed if a person is slated for consular processing to go back to their home country for for an interview at the U.S. Embassy. They could only do the 601 after the embassy had determined that they needed the 601. So if they're slated for that process, embassy process, the 601 is not something they would file while here in America. It has to be filed overseas. So the 601, when it's filed here and approved here, it's usually in conjunction with adjustment of status. So why are you asking about him going back overseas? Not unless, did he enter the United States in a way that was a problem for adjustment of status? Contact us, Stephanie. I need more facts. Thank you. How long is the process for a U.S. citizen mother filing for her daughter that's in the U.S. over 21? So here you have a U.S. citizen mother filing for an adult daughter. It's going to take several years, but the daughter overstayed, so the daughter will not be able to adjust her status. The daughter will need to go back. Let's see, can I do this here? I want to, no, I won't be able to do it on here. The daughter will need to go back, file a waiver, and go back home for an embassy process. Okay, let's see something here. I want to, trying to put someone in timeout here, but I have to get into the back end here on YouTube in order to do that. Let's do this. Come on in and type in freedom now. Okay, let's keep moving because, okay, we're going to keep going. Yeah, thank you. You're welcome. William asks, does being deported from the U.S. and returning illegally count as disqualifying criminal history when applying for a marriage green card? It's not considered a disqualifying criminal history. It's considered a disqualifying immigration inadmissibility problem, because if you were deported and you returned illegally, you triggered what's known as the permanent bar, and as such you're ineligible, not qualified for a marriage green card, particularly through adjustment of status. You would actually have to go back and spend 10 years outside of the United States in order for you to be eligible to try to get a green card. Okay. All right. Freedom now. We've already if you're coming on board and you're seeing this session, just know that we've already discussed parole in place, PIP. You can watch the replay. Any update about those asylum applicants whose removal is dropped because of the government new program? Meaning that the government, you got your case dismissed in court, you got it dismissed. There is no, I don't have any particular update addressing asylum applicants, but if your case was dismissed in removal proceedings, then that's it. You're going to have to find another way. And for many people, they absolutely don't have a pathway to a green card, which is why they had applied for asylum to begin with. Came here with the C1D visa. Can I apply for a PIP? No, you're ineligible for PIP at this time, based on what we know about PIP. Let's see. I have a 601 pending since 2008, no answer until now. That's very unusual, by the way. Okay, Fernandez, very unusual for 601 to be pending for so long. You could reach out to us so that we could take a look at what could potentially be going on there. But I would be very surprised if you still have that, if it still, in fact, is pending. It's very unusual. Let's see. I've already addressed the mother filing for adult daughter, how long that takes. Let's see. I'm going to actually have to jump off shortly. What happens when you are under federal benefits? I'm not sure what you mean by that, under federal benefits. What type of benefits do you have or had you received? And what is your immigration status? Those are the questions that I'm curious about. Let's see. What happened if I have been denied for not providing enough evidence? Can I divorce and get married to another person? If you have been denied because your first marriage case failed, it doesn't mean that your next case is going to be denied. If you make the personal decision to divorce and marry someone else, that's your decision to make. And if you do so, you want to make sure, however, that your second case is filed correctly and that the immigration lawyer who you work with knows about your first filing and has seen the records related to the first filing to really understand how the government thought about your case and whether there are any flags in the system concerning you moving forward. You can contact us. We'd be happy to have that discussion with you if you decide to move on and try again. Okay, with love. That's your personal decision to make. If that happens for you, great. You can reach out to us and we could have a discussion with you about your case, your new case. The DV lottery program is real. Yes, the U.S. government does issue green cards by a lottery system to countries that have historically very low levels of immigrants coming from. And so you can, that process usually begins in the fall. You could go on the U.S. State Department's website, just Google U.S. DV lottery, U.S. State Department, and it'll pull up the page that takes you through all of the steps of the DV process, how it works, and what the timeline is like, and when you can submit your entry. And yes, it is very real. People get their interviews at the U.S. Embassy, and then they come in and get a green card. So it's a real program. Our number is scrolling on the screen, I believe. It's 888-462-4006. And also, if you're interested in PIP, parole in place, you can fill out our free little form at McBeanlaw.com/PIP, and we'll contact you if we think that you might have a way forward with PIP, and we'll talk with you about a consultation with our office. Thank you. And my name is also scrolling on the screen as well. Someone says, Kelly says that I came to the U.S. in 2019 and I went back home twice. I was supposed to go back home again, but I was told to stay because there are going to be plans for those who are undocumented, and therefore I overstayed. Kelly, what you should know is that whenever whenever our government is in the process of doing anything for immigrants, right, particularly on an amnesty level, then what you should know is that it usually historically impacts people who have been here for a very long time, at a minimum 10 years. Okay? So you're going to need a pathway to a green card. I filed an I-130 in August of last year, and I still have not heard from USCIS, Nicole says. Well, Nicole, the question is what category are you in? Because if you're in a preference category, those take a very long time, even for the I-130 to be approved. Okay, so work with check USCIS's website on the process and time for the I-130. I heard that Trump will be doing a massive deportation. Does that apply to me? So first of all, Kelly, Trump will have to be president in order for there to even be a mass deportation plan, and he's not president. He might not even be on track right now. Some will make the argument that he's not on track to become president a second time, but let's see what the voters think in November. And if he does in fact come into office, back into office, mass deportation is, it's foolishness. It's foolish because mass deportation is not realistic from a system level, and they know that. but it's when mass deportation is mentioned, it gets people riled up in the right direction that could lead them to vote for him. So that's all that this really is rhetoric. Yes, they can ramp up deportations and ramp up rounding people up, detaining people, but as far as deporting them, there is still due process rights, and he has not abolished the Constitution. You're right, we still have a Constitution, and we also still have a Supreme Court that sometimes they don't do what we always want them to do, right? But we still have a Supreme Court, and we still have a Congress. We still have checks and balances in our system. So mass deportation is not something that I think that you should really worry about if Trump in fact wins in November. I'm going to take just a couple more questions before I go for my consultations, which are starting very soon. We've talked about parole in place at the beginning of today's broadcast. Go back and watch it once I get off this session. Thank you. Let's see. My daughter is turning 21 in October. Can I do the paperwork before that date? Trish is asking. So Trish, what you can do, you could start working with an immigration lawyer on the case, of course. Most firms like ours, we have payment plans, and that allows the client to make installment payments, and while your payments are coming in, we're working on the case, and then it could be filed later on. But for you now, you cannot send the case to the government until your daughter turns 21, but certainly work on it ahead of time and get it going, get it ready, and just send it out in October once she's 21. Let's see. Let's keep going. One or two more questions. Joyce says, by December, I would have lived in the United States for 10 years, and I have a U.S. citizen child. Can I qualify for cancellation of removal? Joyce, in order to be qualified for cancellation of removal, you must be in removal proceedings currently. It's an application that needs to be filed with the court, and you would have needed the 10 years under your the 10 years on your record of being here in the United States before being placed in removal in most cases. And you're just not there yet. But if you'd like to learn more about cancellation of removal, I know that I do have an old video out there on McBean Immigration TV about cancellation of removal. So go back and watch it, where I talked about what's really required for cancellation of removal. Friends, we do the EB-3. Someone is asking, do we do EB-3 visa petition? Yes, we do. We work with employers on the EB-3 process. So if your employer wants to file for you, sponsor you, the employer can have a meeting with us so that we can, in fact, get that case started for you. Now, let's see. I'm going to jump off now because I've got to get to my meeting. I'll be live later today for those of you who are following me on TikTok or Facebook. I'll be live again today for another session to keep the discussion going. So if I didn't get to your questions today, feel free to join later on today. It's going to be, let's see, I'll give you the time slot. It's going to be between, I want to say it's going to be between 4 and 5:30, okay? I'll be live on TikTok at McBean Immigration Law, or you could watch on Facebook. Thanks so much, friends, for being with me. Give our office a call. The office is open and working. Book your consultation. It's 888-462-4006. Thanks so much for being with me today, guys. You are the best, and I enjoyed speaking with you. Have a wonderful rest of your day. I'll be back also on Friday. Friday, you could catch our news summary roundup between 5 and 6 p.m. See you guys then. Bye-bye.